You're live. All right, welcome back everybody to House Energy and Digital Infrastructure for our last session of the week. We are here talking about our committee bill DR 260726, an act relating to copper-based to fiber-based network transitions. And we are looking at draft 1.2 dated February 5th at 10 a.m. It's posted on our website. We're going to walk through the bill and discuss changes with Maria Royal of Ledge Council, and then we're going to get discuss the bill with some folks here from DPS and PUC. So we'll just go around and introduce ourselves. I'm Kathleen James from Manchester.
Scott Campbell from St. Johnsbury.
Richard Bailey, Memorial 2.
Chris Morrow, Wyndham, Bennington.
Michael Southwood, Illinois 2.
Christopher Howland, Rutland 4.
Derek Corey, Washington 2.
Graham Flubner, Chittenden 15, Burlington.
And Laura Spilio, Wyndham 2.
And in the room, please.
Danny Perry, Pastor.
Claire Buckley, Leonard, Public Affairs, or CPI.
Oh, Representative Emily Harris Duncan, we've invited to Camp Halifax.
Charlotte Washington from the pipeline out the smaller shelters and Trenton goes on the position.
Jim Porter, Department of Public Service.
I'm Daniel Burke from the Public Utility Commission.
Thank you for being here. All right, for the record.
And I'm Maria Royal with Legislative Council. So we're going to go through this draft 1.2. And as it says at the top, the revisions are highlighted. The revisions that were suggested by this committee in your committee discussion, I think that was a week ago, are highlighted in yellow. And then there were some suggested revisions from the Department of Public Service through Hunter. And those are highlighted in blue.
That is really helpful. Thank you.
Okay, and there's some overlap. So you'll notice right away, especially in the beginning. So again, this is concerning the transition from a copper-based network to a fiber-based network. There are no changes to the findings. The changes have to do with the disclosures, the notice that's given when there is such a network transition. So the first change is in terms of the written notice. It shall be by first class mail and electronic mail. I think you wanted to provide both of those requirements.
Yep.
And then you also wanted the notice to go not just to the Commissioner of Public Service, but also to the 911 board.
Can I pause you for 1 sec? I just want to make sure committee members know, because, you know, a lot of times, you know, we're talking to Ledge Council, we're trying to make sure everybody's comments are incorporated. So this draft reflects comments from the E911 board. It reflects our committee discussion. It reflects the written comments that we requested from Hunter at DPS. So basically, this is intended to be a draft that incorporates what we believe is the committee consensus or majority opinion looking to vote. Okay, so I just want to make sure that folks know this is your time to ask questions. We're making decisions right now on the yellow versus the blue. And so if you've got questions or thoughts, this is a really important time to speak up. Okay, so yeah, Rep. Kleckner?
I just have a color coding question. It seems to me that the request that the E911 board be notified came from us, but you have it coded blue as a DPS.
I'm sorry, it came from both. So
Okay.
yeah.
And you know, it's like the one above also, I think we want an electronic.
So the blue, if there was consensus, well, actually, that's not those. I think there was consensus on these areas. So technically, I probably should have put them in yellow and just said the department agreed with these changes.
Okay.
Yeah,
Thank you.
I apologize for not making that clear.
Rep. Torrey?
Okay. All right. My question's more foundational for me. Are these
notice requirements going to affect all of our telco or only when the filing to the FCC happens?
It's whenever there's a change in the network, the infrastructure itself from copper to fiber, which they have to send a notice to the FCC.
Because we did hear from Franklin
Yeah.
and they said that they didn't.
Okay, so this is part of the confusion, and I was gonna wait at the end. Yeah, it is confusing.
wait
I
till
was
the end?
confused. Maybe we'll just go through just to see if for now it reflects.
Thank you.
And then based on that broader discussion, if there are other revisions you might want or things that you might want to hear more about. Does that make sense?
Yeah. And I just want to reiterate, folks, that as we go through, this is how it reads. And if we're not hearing questions or comments and it reflects what we've talked about, I'm checking it off. Okay? So mail and email.
That's right. And also notice to the 911 board, and then that on line 15, changing to 120 and 30 days, that's from Hunter. I don't think you discussed changing when those notices go out.
Okay, so this is a good time to do that. 120 days versus 90. That's a suggestion from Hunter.
Oh, I think it's versus 90 and 60. Is that correct?
That's correct. So it would so instead of 90, 60, and 30, it would be 120 and 30.
So that's one less notification.
I think it needs to have 60 in there. Because if somebody doesn't read or remember the 120 days, then all of a sudden, bang, it's a 30 days.
Yes.
Yeah.
Sorry. So I would tend to agree with Rep. Southworth, except I think in this language, what we are doing is also saying that the commission is going to say how they have to provide the notice. And right now, what they're providing is it's like a little marketing thing. So people don't, I think, are missing the point in many cases of what's happening. So I'm looking to see from Maria if in fact that is what we are doing here. We're requiring a specific type of communication. We're changing what we sent. It's not up to them exactly.
Well, that's right. You're basically setting the minimum requirements, and then you're allowing the commissioner to add additional items that are consistent with your purpose. So the minimum would be what you said here in terms of when the notice goes out.
Mhm.
You can set it at whatever you want. If there were an instance or for some reason the commissioner felt like additional notices, not less notices, but additional notices were necessary, that would be required.
So my gut is either we stay with 90, 60, and 30, or we move it as Rep. Southworth suggested to 120, 60, and 30. Maybe I think 4 is overkill. Thoughts?
I like
Yeah.
Rep. Southworth's suggestion. 120, 60, and 30.
Okay.
As much as it pains me to agree with my colleagues on that, I do agree as well.
Thank you.
Yes, you said
I've noted
on the left.
date.
Okay.
So then in terms of what's included in the notice, no change to number 1, the date the transition is expected to occur. Just a technical change in number 2 from impacts to impact on. These were the details of the service changes. There was a proposal, I believe, in here and also by the department to delete that provision as it pertains to broadband service. I think I think part of the concern was, are we preempted from doing that? I don't think you are. If you feel like customers should know what services are available, there's nothing, I don't think that preempts you from doing that. Whether you think it's necessary, that's up to you.
So this kind of leads into one of my concerns. So we have heard and read testimony where And I've asked this before, where VoIP is considered internet service. Then we have landline copper-based service. And if I'm not mistaken, we read, or I read somewhere that they were considering that a internet-based service, so that it was no longer gonna fall under area of last resort. And that's concerning to me.
It is concerning and it's really confusing. But the short answer is, so the FCC has, I don't believe it's ever actually classified VoIP service, fixed VoIP service, so that's to a specific location, as an information service or as a telecom service. But it is subject to some regulations. It is not data. It's not like broadband. I don't know that it's ever been, maybe in the early years, there was some thought that states, the FCC can't regulate VoIP as a telecom service to any extent. But at this point, it's not like broadband. It's not subject to the same preemption challenges. There's a little more leeway, particularly when it's interconnected VoIP. That means it intersects with a 10-digit dialing system, the public switch telephone network. And if it's fixed VoIP, that means it goes right to a person's house or the location. It's an issue if you're replacing a landline service, a copper service. So now that the only service available is a VoIP service. Some states have completely deregulated and said there's enough competition, we're not going to regulate. Other states have felt differently. So there's things to consider about the extent to which you would want to regulate. I think, I'm not saying you can entirely regulate VoIP as if it were a common carrier under Title II. But some of it's, what are the concerns? What are the public safety risks? When it comes down to it, about the services that are available in Vermont. And again, different states feel differently. The FTC tends to modernize the network, replace everything with fiber. There's a lot of competition, wireless, other wireline providers, cable providers, but the market will kind of take care of itself. That's definitely one policy choice. The question is, does that work in Vermont? And so I think that's part of what you're going to also be hearing from the PUC and the department about what status is now in Vermont and what they're asking to be relieved of.
Okay.
Yeah. Does that make sense? It is confusing.
And I know we're going to talk about that later. Thoughts on this
Yeah.
blue box?
I have.
Yep.
This is the blue box being striking broadband service. Right?
Yeah.
Since we're setting a minimum, I could understand striking that. I would imagine that any private carrier would want to advertise their broadband service if they were doing that, right? So what we're talking about is an address dedicated telephone service. And in fact, I wonder if that might not be a better term than current telephone service.
Or legacy telephone service.
Well, the impact will be on their telephone service.
Right, legacy voice service. It's usually how it's.
Well, it's a change from the legacy voice service to another telephone service, right? To another voice service.
Yes. Yep.
So the impact will be on the voice telephone service.
It'll be on
It's a change. It's a change from where I'm interpreting anyway. To change from copper-based voice service to fiber-based voice service.
So this is where it gets a little bit confusing. Because for some of I think when you heard from Kim Gates, when she was talking about, we don't send a notice, we changed our network to fiber and everybody, it was almost seamless. They didn't, there might have been some technical changes. So in a sense, they still have a legacy service because the phone company isn't being relieved of its obligations in any way than it had before. There's really no difference. It's like a legacy voice service.
Right.
What's happening here originally, I think we approached it as this is just a network change from copper to fiber. But what's actually going on is they're asking for permission to be relieved of their legacy service. Which is why when you said that, I thought, well, okay, the impact on the customer's legacy voice service as compared,
Right.
with switching to the replacement voice service, which is
But they-
not necessarily a regulated legacy voice service. Is that
Well, are they still being required, obligated to provide a voice service?
that's to be determined? That's
By who?
they are asking there. So this is what was confusing, and I think why there were different things being said. That's why Kim was like, we don't need to get FCC. Technically, I think they have to submit a certification to FCC, but it's really minor, right? You're just changing the network. Everyone's service is the same. What Consolidated is asking for is to discontinue having to provide their legacy voice service and being relieved of the obligations that accompany that service. That's what they have asked of the FCC.
So they're being relieved of that obligation to provide any telephone service, really. It's not, when you say legacy, I'm hearing copper.
Correct, but it's not always copper because like Kim Gates and her company, she has fiber, but she still provides what's considered legacy voice service, subject to all of the carrier of last resort service requirements. The
Okay, so
EPC.
there's legacy in the sense of a legal obligation. And there's legacy in the sense of technology. It's
Yeah.
this is
Yeah.
fine.
Yeah, and I think you're absolutely right, though, to be really clear about the distinction and what's being asked. And that's where I was gonna say, in light of kind of like what's actually happening, do you want to refine this anyway? Do you want to understand a little bit more about what's happening in the market, how it affects Vermonters?
Well, maybe for myself, maybe I wasn't understanding correctly, so.
I didn't understand either.
Yeah.
So, no,
So maybe we do need to ask Fish.
Well, that's why they're here.
Yeah, okay,
And we will be hearing from them.
okay, well, we can go on, but
Well,
yeah.
so do we want to flag?
yes.
Is there a problem with the word current? I guess is my question. And if there is, let's hear testimony from our folks in the room after we finish our walkthrough and return to that.
Okay, I'll note that
Okay.
we might change the terms
Okay.
to make it consistent with what you want.
All right, so that's TBD. So getting back to and broadband service as applicable. If you don't think it's getting us into thin ice with regulatory stuff, I don't see why we wouldn't leave it in.
I don't think so. If the customer has voice and DSL service, they're getting a notification of how this new fiber service is going to impact what they have.
Well, even.
And you're right that
Yeah, right.
presumably that would they'd want to advertise you're
Yes.
getting fiber service. There might
Nobody
be
would like that.
price variables, but
Yeah.
which gets at, so what's added there at the end of subdivision 2 and whether the carrier will offer a reasonably comparable replacement service in relation to pricing terms and conditions. This is getting at what came up in subdivision 3. I'm sorry, no, further down in subdivision 4. They have an obligation to provide a calling plan at the same price as offered. And so I think you raised good questions. Like, is it actually at the same price? What happens if they want to raise the price?
Or lower the price.
Or lower the price? And so this is just a notice. Is there a service that's comparable? Same terms. It doesn't require there to be, it kind of leaves it open. It's just a notice so that customers know they have options. And then number 3, so this is both Hunter and this committee wanted to amend that language about auxiliary devices. So it now reads that they provide information sufficient to inform customers on the need to test and verify any auxiliary telecommunications devices such as alarm systems and life alert to ensure they function properly over the new VoIP. So just informing them that this is an issue and they want to make sure that your device is still functioning.
Everybody okay with that?
I wonder if we should say, instead of Life Alert, which is a brand,
Branding.
medical.
Oh, medical
services.
alert system. or
Oh, that's
something?
good.
Okay, yep, sure.
Okay, and then striking what follows because we've replaced it.
Right, and that
Okay.
was, the replacement was, they have to provide the technical support and like, there were plenty of questions raised about whether they should do that or even know how to do that.
Yeah,
So number 4, this no change to the first part. So disclosures about the carrier's obligation to provide regulated landline voice service to all residential customers in its service territory. It's not saying that they will, but it's saying that you need to inform them if you are under an obligation to do that. So, I mean, this is the issue that you're going to come back to
Mhm.
when you, so I'm just flagging that now, but it's, it gets to informing customers about what the
What
provider
is-
has to provide. And then, what I referenced before about having the same price calling plan, striking that in subdivision 5. This is about the backup power, making that informational, only information on the need for and availability of backup power options and battery backup devices to ensure each customer can maintain service continuity during a power outage. No longer required to disclose specific costs or installation procedures, etc. And then subdivision 6, Hunter had proposed they now have to provide a brief summary of the consumer protection rules, just the link. And then I amended the rules. It had been rule 3.30 because we've been talking about the disconnection rule, and that's for electric and wire. And so it wasn't until this morning that I realized, wait a minute, I think they're different rules. But there's similar consumer protection rules that are applied to telecom service with respect to standards for billing, credit collections, consumer bill of rights. And those rules currently apply to fixed VoIP services. So, informational, contact information for support, department from the carrier. And then I think what came up in your discussion was asking that they provide information regarding the availability of and eligibility for any federal, state, or carrier discount programs applicable to the replacement VoIP service. Again, informational, and then a general catch-all, any other disclosures deemed necessary. And then the language, so it had read that those disclosures are consistent with the purpose of this section. What I added next is, or what instead, it specifies to ensure that the public convenience and necessity will not be adversely affected by the transition or discontinuous. You're going to decide that. When we kind of get a little bit deeper into that discussion, but that's the standard that the FCC applies when it's evaluating whether or not to allow a provider to discontinue its legacy service. So it seemed like it would be appropriate to reference that's what the department's going to be thinking about in terms of these disclosures and how to protect Vermonters and their interests. No changes to the VoIP service provider reporting section. The DPS did recommend that this subsection be stricken. Did I miss a change? Was there a change?
I probably missed it. Transition or discontinue service and on line 13, is that?
We're gonna talk.
That's to be
We're
determined.
coming back to that.
That's, yeah,
Okay.
that's exactly, yeah.
Okay.
Yeah, I just wanted to kind of highlight
Yeah, all right.
one of those areas. So, again, this is asking the provider to annually report the number of customers, who have purchased battery backup systems from the carrier. That's assuming that they offer it. It's not requiring them, but if they know, if they do offer it, that they also disclose the cost of those options. And then if they happen to know, any incidents where 911 access was impaired due to the lack of backup power. So if you think that information would be helpful, and this would apply to all VoIP providers, not just what Consolidated is offering. So any fixed VoIP provider. So
Yeah, I want to hear, I saw your hand. I want to hear why this is useful information. I don't remember, I remember thinking that thought this maybe wasn't that helpful.
and now to say this came from April 11, but there was some talk about the battery backup issues.
Yeah.
We incorporate some of them. So this was just moved over. That's where it came from originally.
Yeah, I thought we were striking this, but it was your,
The recommendation, there was a recommendation from the department to strike this, and I think we should talk about it. So we are potentially, not potentially, we are in the process of seeing the way that people are able to call for help, you know, cross the final threshold here. You know, we put in place, period. It is very different, whether or not it's guaranteed that they're able to do that. And we're gonna hear more from the department and the PUC, about their assessment and monitoring of that. But I fail to understand, you know, we heard some concern about, well, this might, you know, if there's a whole house generator, you wouldn't need that. This simply says, this information is gonna be provided to the department. And it seems like important information for the department to be able to monitor what is happening in this very serious transition that's happening here. It literally, it's about some of our parents and grandparents being able to.
but let me think this, help me think this through.
Yeah.
So it's the providers who are going to have to report to the department
That's right.
how many customers who have bought batteries from the provider.
Mhm.
But can't you also go buy a battery somewhere else or from somebody
Yeah,
else?
so they might not know that.
So it's going to be
Mhm.
incomplete data.
Mhm.
So we're not going to know how accurate it is because it may not capture the whole universe of people who are buying batteries.
That's right.
The cost,
It's only for what they charge.
Mhm.
right, and that would be fluctuating all the time, I assume. I don't know. If you buy it special sale from Consolidated in April, and then does it cost differently? So I'm not sure about the relevance of that. And then I don't know why we're asking the providers to tell us where E911 access was impaired due to the lack of backup. That seems like it will come from the E911 board. So
So
I don't get this report.
we are, our regulators, and I'm very interested in hearing what they have to say, have blinders that are starting to come over their eyes in terms of understanding who can call for help. And so this is not going to give us comprehensive information. And I don't think that it alludes to, nor is there anything we're requiring to be done with this. I don't believe we're requiring anything to be done. We are requiring this information to go to the department so that the department has more data. We can't require these providers to do a lot of things, but they have more data when they are hopefully monitoring and assessing. Okay, you know, like in this section of Vermont, and I know that they do this, you know, we are seeing there's some pretty serious repeated power situations. We know that there's not a lot of batteries, like maybe we have people that are really vulnerable here. There's some sort of funding, maybe that's a place to, it is data that can help us understand vulnerability and help the department understand vulnerability. And this is not a static environment we're in. We are literally starting to handcuff this change in this transition in technology, our department and our ability to protect Vermonters. So this is data to just help us have an indication where there may be vulnerabilities. No requirement to use it.
So I'm just kind of gonna add to that. I'm not disputing, I'm not arguing. But didn't the requirement to provide battery backups for sale, didn't that requirement sunset?
Exactly.
So with that, why would they keep any of those records? That's,
To answer that, I think they know how many things they've sold. Right? They have to keep track of that.
Who's saying?
The utility that is selling battery backup systems, the provider that's selling battery backup systems to their customers, which are the only ones we're going to know about. I think that's not a big requirement, but my bigger question is, like, what we really care about, I think, is line 19. And is there another way to find out how many people tried to call 911 and couldn't? Is there a way to get a more complete picture of that than this would provide without requiring other things that only give us an incomplete picture?
And would the provider even be the person who knows that? That was one of my final points. I agree. I think line 19 is really important. I was trying to articulate who has that information. I don't know that it's the provider, or is it?
I don't know that you make a call that doesn't go through unless you report that, nobody knows. And if you're a Vermonter out there who tried to call 911 and it didn't work, you're probably very upset about that, but you may not know.
Why?
There's no obvious place. Like, I wouldn't know who to call up and complain about. Like, if I made a call and it didn't work, I wouldn't know. Like, who do I complain to? Do I complain to my town manager? Do I complain to my phone company? Do I complain to the state government or the FCC? Like, I would not know that.
A lot of our board spurians complain.
Or would I complain to Sibilia?
Yeah.
Yes.
Madam Chair. Yeah. So this is not there's not a requirement. There's not a penalty for missing this. I think this language presumes that all of the actors here, which I think is extremely generous, are wanting to protect Vermonters, their clients, and ensure that their clients have access to E911. I think this language, which doesn't require or penalize, it allows it says to the providers, we want to know if you understand that there's an issue, and it just presumes that there's good intent. Again, I think that's very generous in some cases, but there's no requirement or penalty here.
Yeah, I understand that. I mean, I'm not going to go to the mat over this. It'll be interesting to see if the data is useful. So unless people want to argue further about striking it. I think the cost of battery backup options is, then I would say the cost of sale or something, and we can move on.
Do we know why DPS recommended striking this out?
If I recall the conversation, it was probably along the lines of conversation we're having right now. So, all right, well, I've made my point. I'm not going to, it's not my hill.
In the enforcement section, no changes there. The department monitoring, I have this down as a to be determined. I wasn't sure where the committee landed on this. DPS recommends striking this subsection in its entirety. So we'll just read through it once more. So in addition to reviewing the reports that we just talked about that come in from the carrier, the Commissioner of Public Service shall review the quarterly outage or the outage reports that are submitted to 911 by carriers and by electric companies about any network or power outages. Commissioner reviews those quarterly. In addition to reviewing the department's own telecom service availability data, that's new language. And the goal is to determine if there are areas of the state particularly prone to carrier or power outages and assess whether locations in those areas may be vulnerable to extended periods of time without access to 911. So in part, what that would be based on is if there's only one wireline voice provider, if there's no cell service available, if there's only one wireline provider and the network is down for a sustained period of time, then no calls can be made. If the power is out for weeks or week, then to be concerned. They don't have any other options. Do they have a generator? Do they have that? Right. So it's policy decision if this information is helpful to you and think it can be monitored in a meaningful way.
So I think the purpose is really important here. Determine if there are areas of the state particularly prone to carrier power outages. Assessing whether or not those areas might be vulnerable. Previous legislatures have spent a lot of time on the vulnerability that was opening up in the state. We added, incentivized these publicly accountable entities. And let me just take a moment right now to disclose that I am a board member on the Vermont Community Broadband Board. And I'm not speaking for them. I'm observing as a legislator what has transpired. We saw this happening. We legislators incentivized the creation of more accountable entities as we were seeing deregulation about to happen, ensuring universal service. And what we have seen, and what we are seeing with our CUDs is tremendous success in some areas. And some of that success is in partnership with an entity that there continue to be many, many complaints about. So I would say we have one actor in the state who's partnering and continuing to transition on their own, who has been a bad. And so we still are going to have vulnerabilities even after this action. And so this would require the department to monitor. We're saying we want you to monitor if there are areas of the state where there are vulnerabilities, as there were before we passed Act 71 and Act 79. But I think we should keep it in there. I think we relieved the department of a lot of obligation under Act 71 and Act 79, which was the creation of CUDs and then the creation of the VCBB. We now need someone to really, this is not the VCBB's job. We need our regulator to monitor what is happening.
Maria, in a section like this, I agree the outcome is important. Is it necessary for us to be so prescriptive about what we expect them to monitor, or to review or read in order to deliver these results? You see what I'm saying?
Yeah.
It's like we're saying we want to know, if there are areas of the state prone to carrier or power outages and assess whether they're vulnerable. I think that's really important. I think we should keep that in. So I don't agree with DPS on striking that. But do we need to give them like a homework list to do that? Like, do we have to tell them what to read to do that? I am asking you legally. And that's say, here's what we expect you to deliver.
Yeah, and that's part of why, based on kind of where the conversation's going in your discussion, I added in here, she'll also look at their telecom service availability data.
Mhm.
So as an overlay, okay, a lot of power outages here, only one VoIP provider, right? So they can, that was helpful information. If there's other information that you're aware of, you want them to look at, or if you just want to say including, and they can look where they can do whatever they want. They can request information from where they regulate. So you have a lot of flexibility. You can be more prescriptive. You can be less.
I think it's an important report. So if you think this language gets us where we're going, I'm good with it. Anybody else?
I would be happy to hear any additional comments that the department has given. our discussions with Village Council today. There, if they have additional suggestions on how we could achieve the outcome that we're looking for.
Okay,
Okay, and so no change. I don't think this committee wants to make change to coordinate with the AG's office about establishing a mechanism for tracking consumer complaints related to VoIP service quality and reliability. Consumer education outreach, no changes there. That's the obligation of the commissioner to make sure customers understand how they'll be impacted by the transition. Also, additional information about the risks concerning emergency preparedness with respect to VoIP service. Again, the power outage battery issue. And then for the department report, Commissioner shall include in the annual report to you findings and recommendations related to the implementation and enforcement of this section. And then the remaining one-time reporting requirement, the department or Director Thompson recommended striking. This is the report that would come back next year only about whether asking for recommendations about what other financial assistance is warranted for low-income customers with respect to purchasing backup power, and whether the state should enact any additional backup power obligations applicable to VoIP service. So along the lines of what the FCC has sunset. So these are, again, just recommendations. And that includes everybody.
all right. And I know the effective date, we feel like gives sufficient notice, basically, right? So, to the providers for the change in.
That's all I have. And so just getting back here.
Actually, Madam Chair.
Yeah.
Why, I forget why we have that effective date. And so
I thought that was one.
So it takes effect on passage. It applies to carriers on September 1st. You can change that. This was a little bit of leeway to prepare their notices, but we don't need that. That's
notices. Yes, okay, thank you.
Right.
Thanks.
and so the
And giving
department
the DPS time to
Yes,
come up with the form.
decide the matter and form.
That's
Okay. Yeah, Rich
So
Southwood.
along those lines, with the rate that the filings are happening,
Mhm.
this is going to miss a large quantity of those.
Have to get our friends in the Senate and the governor to say, beat.
Okay, wanted to state that.
By August. Could we say 60 days after passage? Does that potentially move it out longer? I mean, potentially that moves it up faster, right? Although that's a lot of uncertainty, that'll make people very anxious. I don't think we're gonna save much. That we're probably not gonna get this fast before. July, August.
My concern is we're going to enact something that's going to be way behind the times, and it's all gonna be done before this even takes effect.
But it takes time. I mean, we need to allow time for the process. I mean, it takes effect.
I understand.
It takes effect on passage. So let's say something really weird happens and we vote it out next week. It's on the floor. It goes to the Senate. They're like, great idea. And they ship it off to the governor and he signs it right away. Then it will have taken effect. And then I would assume DPS would begin the work of deciding the form and manner, and everybody will be on notice that this change is happening. So I'm not sure how to make that faster without.
I think that gets back to, should you just specify a number of days after passage? All right.
Like 60 or 90.
How much time do they need from enactment? I mean, this says September 1, but they could enact it, I mean, under your scenario, wouldn't it be great? It's enacted in April. Could be July 1st, you know. Well, not would it be July. Come on.
May I just respond to Representative Saunders? So I'm not sure we can get ahead of this that much, and I share your concern, which makes the requirements for monitoring that we're putting on the department and data collection even more important. Because we may be trying to shut the door after the worst out. So now we're gonna have to monitor.
One last point. Weren't we going to wait to see the MOU at some point to review that?
We decided not to wait for the MOU.
Okay.
Because Hunter said it could be several weeks. And he said that that there were parallel tracks. He would submit comments, which he's done, and we would revise the bill accordingly. And they're working on the MOU. But especially considering the conversation we just had about the horses out of the barn, waiting to see an MOU and then trying to revise this again accordingly, we could lose a lot of time or lose the bill.
Yes. Yeah, that's all I have about this. But just in terms of the issue of now, what is actually being requested, a little more information about that. So some of the applications that were filed with the FCC by Consolidated are to discontinue their legacy service. So the question is, what does that mean in Vermont? That's what you're going to hear from the PUC and the department about. Consolidated operates under an incentive regulation plan. There's a lot more flexibility than there used to be for the traditional regulated service, a lot more flexibility on price. There are some metrics about competition. If there is enough competition over a certain threshold, they can be relieved of certain responsibilities. I don't know. I haven't looked at the incentive regulation plan. So I think that's the question of like, what are they obligated to do now? And would discontinuing their obligations under their new application go further than what they're required to do now, or is it consistent with what they're required to do? That, I think that's what you're gonna hear more about.
That makes sense. And what, sorry, when was that? Well, here, that's a recent filing.
Well, one that I saw was from December. It was filed in December, but I think there may have been a previous one. But I think that's information. How many have been filed? What areas? I don't know the details about that. So,
All right, great.
And that's where my concern comes in.
that's exactly where your
Because
concern comes in.
from a letter dated 3 days ago from the carrier that we're talking about, it stated, these are not copper retirement filings. They are filings to discontinue legacy voice services. And that right there is what concerns me.
Mm-hmm. Mm-hmm.
Yeah, so the questions that you look at are prices in any way regulated or capped? Are there carrier of last resort responsibilities? Do they have to build out to new builds? Any other households that they don't already provide service to? What are the service quality provisions that would still apply? Whether they still will retain their ETC, eligible telecommunications carrier designation, which allows them to receive federal funding. And it also requires them to offer lifeline service, federal and state. So I think these are all the things about you're going to hear about how does it change? And that's part of what's under the incentive regulation plan. And I'm not sure of all the details.
So I guess my question is, along Representative Southworth's question is, they make this filing to the FCC. Are they legally allowed to, is the FCC legally allowed to terminate their obligation under state? So
this is a really interesting question because, yeah, they filed applications with the FCC and under that procedure, there's like a 30-day window to make comments. So you should hear from the PUC about their notice or whether they have concerns. In terms of what residual reserved authority the state has, if the this is a contentious issue. Some providers are arguing if the FCC approves this, the states do not have any authority to undo what the FCC has already said. You're preempted. The FCC says this is okay. We've looked at the public necessity. We've looked at the competition. It's fine. Other states, notably California, have said, I don't think so. We're going to study this. We want to know if our customers are protected. And we think we have jurisdiction to decide what's in the best interest of our state under 10th Amendment, public safety, public health authority, state authority. So,
Does anybody know if this is on our Attorney General's radar?
I don't know, but it might be helpful to hear thoughts from the PUC's
Yeah.
perspective
Sure.
of what they believe their authority is and how they're responding or have responded or what.
So I know, Maria, I know you're gonna stay, so,
Thank you.
Sure.
yeah. You guys ready?
Sure.
Sorry, we're running late.
We're gonna go sequentially or together?
Joe, you go first.
Whatever you want.
What? Yeah, but
I would defer to you.
whatever's.
I can sit with you.
Come on.
Get him a brown shirt. I see this.
Long time.
Just one to write more long versus work.
Is there one?
You're an attorney. You can go after the chairs.
For the record, I'm Jim Porter. I'm the Director for Public Advocacy with the Department of Public Service.
And I'm Daniel Berg. I'm a staff attorney and hearing officer at the Public Utility Commission.
And maybe just very quickly, does everybody here understand? And I think primarily we're talking about consolidated, and Maria absolutely is correct. There's a federal regulatory scheme and a state regulatory scheme. But years ago, if you remember AT&T, they were the monopoly and the phone company. Well, here, but I mean, yeah, way back. And they were rate regulated to an extent, and they were regulated much like Green Mountain Power. They had a monopoly product and a monopoly service area. In 1996, Congress passed the Communications Act, and at this time, they said, we need some competition introduced into the market. At some point, the Bell companies were broken up, and Consolidated is still a successor in interest to Verizon, who were they, New England Bell maybe. But all of they called them the baby Bell companies. They had obligations that nobody else did because they came from a monopoly, and they continue to have some of those obligations today. But one thing, competition largely was successful for the last 40 years. And it is a competitive market. And we have recognized that. You've heard about their incentive regulation plan that Consolidated and Fairpoint have operated under for years. And I have to say this at the outset. Vermont sort of has gone all in on fiber to the home. I think Hunter will tell you that's preferable. He's excited for the day when everybody has that fiber connection. And Consolidated over the last however many years have made huge investments in Vermont in fiber to the home. And I think that's a good thing, and don't want it to sound like we're not appreciative that they've done that. But what we've done as far as regulating them is the first thing with their IRP, and there's one thing that is still regulated by price, and it's called Basic Local Exchange Service. It's basically the most basic dial tone service that's offered to the customer. They're required to offer it. We call it blessed service. Remember that, because I'm going to come back to it. And that continues. There's a formula, but I believe it continues to be regulated, and that service has to be provided. I think VTEL was our first smaller phone company that went to fiber only. I think you heard from Kim Gates from Franklin Telephone last week. Most of the little guys are fiber, completely fiber now. And they have all, including VTEL, because we believe that the obligations you have to provide voice service are there irrespective of the technology that you use to provide it. And
Right.
yes.
Can I just make one quick distinction, piggybacking off what Jim just said, that's relevant to this discussion for a legal and regulatory purpose, is that Consolidated's bless rate is still rate regulated by the Public Utility Commission under Vermont law. All of the other incumbent telephone companies, including Champlain Valley, VTEL, Franklin, they are not rate regulated. They were rate deregulated by law, 15 years ago, give or take. So the smaller, what we call the ILECs, the old incumbent local exchange carriers, are not rate regulated. They're still subject to the commission's service quality obligations, so we still do regulate them. We're still responsible for various federal filings on behalf of those companies. But in terms of the regulatory posture, vis-a-vis Consolidated, which is the legacy RBOC, which was the regional Bell company, they're in a different posture. So that is why Consolidated has an incentive regulation plan, which governs its bless rate, but the other telephone companies do not.
Just a quick question, Jim, with regard to, you said we believe that they are still obligated to provide, don't let me put words in your mouth, obligated to provide voice service. Is that what you said?
I think they're obligated. Well, I think they're obligated to provide blessed service at a regulated rate.
Through federal or state law?
State law.
And what is that law?
Well, I think it's their incentive regulation plan that the PUC orders.
And I'm digging your chronology. I get
Okay.
it's difficult for me to jump ahead. So if we could stay with like order of operations, that is really helpful for me. So we were back with the baby bell. We were back with the baby bells and price regulation and
Well, and what I was going to say, Comcast has been offering fixed voice service for years and years. You know, we had concerns. They were going to say, don't call us about this service. All the companies that have changed a lot of the technologies, they have continued to abide by the same, Comcast, we take complaints about their broadband service kind of as a courtesy. I will tell you, because we just recently had to extend Consolidated's IRP last year, and we did it the PUC extended it for 1 year. This was the first time that Consolidated has been less than willing to work with the regulators. I think y'all had Sarah Davis from Consolidated in here last week. I've listened to her testimony about 4 times, and I have some questions after listening to her. And one thing I just wanted to tell y'all today, and I'm going to be a little careful, since Dan's with the PUC, I have to be a little careful about. I can tell y'all what our plans are, maybe not so much Dan's. But I think there are some questions under Section 231 of Title 30. You cannot abandon a regulated service without the PUC's permission. I think there's a question, maybe, as to whether that's happening. But one thing that I think we're about to do is to ask the PUC to open an investigation, because after listening to Sarah, and I know we've had Hunter working with Consolidated toward trying to pull together some sort of MOU. If the PUC, if we do this and the PUC opens an investigation, I think we need some answers from the company that are sworn, which happens in PUC proceedings, to kind of find out exactly what they are doing, what their intentions are. What did this filing with the FCC mean? How do you view this obligation? To give us, as I say, a sworn sense of where this company is. And I think that's one thing that the department is poised to request, irrespective of an MOU or this bill. Does that make any sense? There's just too many questions, and yeah. And I imagine I'll listen to Sarah's testimony a few more times before that comes out.
So can we go back just to 101 for a minute?
Yes.
So FCC filing from Consolidated to discontinue legacy voice service. Can you just 101, what does that mean? What would happen if it's granted? When would we expect, how quickly does the FCC move on this? If it's approved, what happens? I want to make sure I really understand
So
what the filing means. And it sounds like you have questions too, but
so the filing that was made back in the summer, the first one, and I've got it here, which I think they made it properly. They sent it to the governor's office and to the PUC. I had a call from the PUC and they said, "Have you seen this filing?" And I said, "No." So frankly, this filing did not concern me. I can't speak for the PUC as to whether they were concerned. I sort of read this as we're getting rid of copper, we're putting in, and Sarah did say, like Sarah Davis said last week, she seemed to concede that they do have these certain voice obligations. But I think that's something we need to look at a little more. I'm sorry, though. Did I answer your question?
so that was okay. So I thought were there two filings. So the filing last summer was to discontinue legacy voice, and then was there a filing in December?
Yeah.
So there were identical filings, but they related to different exchanges throughout Vermont. So Consolidated is obligated to file these when they're doing the work within particular exchanges. So if you look through the stack of paper Jim has, I believe there's maps and lists of exchanges where they're doing particular work. There was a subsequent filing in November, which we did not receive at the Public Utility Commission. In fact, Chair McNamara knocked on my door asking if I had seen it, I think in response to a request from Representative Sibilia. And we had not. And I worked with our clerk, who's very diligent about checking the mail. And she looked through everything she had scanned and found they had sent us a filing that was relevant to Texas at that time. So we did not get their Vermont filing. So Consolidated, I presume it's their law firm in DC that handled that work, sent us the wrong filing. So the clerk didn't forward it on because it didn't look relevant for obvious reasons. And there's a subsequent one. They all have the same information. They speak to discontinuing legacy voice service, but not retiring the copper. And my understanding when I first read these filings, which I was the one from the PUC who reached out to Jim and Hunter Thompson, because we can discuss FCC filings together, was that when they referred to discontinuing legacy service, I understood legacy service to mean TDM service, which is the traditional time division multiplexing service that is done over copper lines. So that is the fancy word for the waves that are sent on copper to transmit your voice. And they'd be switching over to fiber equipment, which uses flashes of light from lasers. And that's where you get the VoIP, which is VoIP. The internet protocol is in there. It doesn't mean they're sending this over the internet. It just means they're using the same type of technology that transmits data on the public internet. So they're still transmitting these calls over their own proprietary network. At least they should be doing that. And my understanding of the federal law is that, I should take another big step back. Attorney Royal referenced the ETC designation, which is the eligible telecommunications carrier. That is a creature of federal law. The companies that are ETCs are eligible to receive funding from the FCC. What's relevant to Consolidated is what's called the high cost support. It's basically a subsidy for providing service in rural areas. And states are responsible for making the ETC designation. So we at the PUC are the state authority here with designating which telephone companies get that. And that's historically the old landline companies. So Consolidated has it, Shore Telecom has it, all the old landline telecom companies have it. And when you are an ETC, you are obligated to provide service, voice service, to every residence subject to certain conditions in your service territory. And you cannot be relieved of that obligation until you go back to your state commission, in this case, us, the PUC, and petition to be relieved of ETC service. And there's certain criteria set out in statute that you have to satisfy to get that. The big one is demonstrating that there is another wireline carrier that has also been designated as an ETC carrier in your service territory. To date, none of the wireline ETCs in Vermont have petitioned the PUC to be exempted from their ETC designation, even though there are now arguably some wireline ETC where some of the pods are. They have not gotten those petitions yet. So Consolidated is still subject to its ETC designation. And as Mr. Porter mentioned, it is also still subject to its IRP, which obligates it to provide voice service and non-competitive exchanges. So I'm sorry, I know that's a fire hose spray of law there, but I would distill that down to it is my interpretation of the relevant law that regardless of what has been filed and approved by the FCC, Consolidated must provide voice service in those exchanges on a standalone basis to its customers. The issue that I think is arising is whether or not they need to do it subject to their approved blast rate. I think that is, I would say yes, but there may be some Consolidated may disagree with it.
I may be missing something here. Yeah, I'm happy. But as I understand it, they filed with the FCC to be relieved of that obligation to provide local service.
What their filing says is they would be relieved of providing legacy service, not that they would stop providing voice service. And under the applicable federal regulation, they have
legacy in a sense is a legal obligation, is it not?
legacy. I interpret that as the TDM service. So that is the frequency sent over copper as opposed to putting up fiber optical equipment. So yeah, it is. Yes, I know there's a lot of overlay of federal and state law. There's almost collaborative federalism and technology that goes in this. But it's also important to bear in mind both federal law and state law are pushing these telephone companies to use fiber as opposed to the old copper for a lot of reasons.
Right. But I think you said earlier that they were petitioning to be relieved of TDM service, legacy, as you interpreted TDM service, but not relieved of actually using copper.
Not retiring copper. There's a very specific definition for what retiring copper means under federal regulations. And they have not done that. They have not petitioned the FCC to do that. So that is a term of art, retirement. It's defined in federal regulation. And that's really getting into the weeds of that. Yeah. So, yeah.
So we're not lawyers. Go ahead.
Sorry, I know you've heard from three attorneys.
Is it possible that Consolidated believes that their application to be relieved of their legacy obligations means that they do not have to fulfill carrier of last resort obligations?
I did not hear Ms. Davis's testimony. I actually looked for it yesterday on the website and was unable to find it. So if you could forward that to me.
Forward that to
Yes.
you.
If that is their interpretation, I speaking for myself, I would recommend to the commissioners that's not how I would advise the commissioners. If there were some sort of regulatory proceedings in front of us, it would ultimately be subject to our three commissioners to make those determinations. That would not be my opinion.
So how many filings have you been privy to so far?
I have seen 3, but I think only one came to us through our normal channels. And when we get them, our clerk uploads them to our filing system and we create a report file.
I think it was 3 days ago, they said they were filing another one on that day. So there's another one already in process.
And you've only received one.
That I have seen, I can't say. I would need to check with our clerk if there was another one that I did not. But she's pretty diligent about scanning them. getting that or being assistance.
Mhm.
Who's next? I don't know who's next. I'm taking notes.
So if the small ILECs have all gone to fiber, this is the non-issue.
Which is a non-issue.
This notice. Everything we've been working on in terms of outreach and, reporting.
I don't know that it's a non-issue. We get very, very few complaints about the small telephone companies in the state, I think. And I think they typically do a really good job with their customers.
And so other than, Consolidated, who are the other ETC larger ones that haven't completed the transition?
Gosh, you said Shoreham was Shoreham. Hunter could answer that.
Okay, I'm just trying to get a sense of
Mr. Burr,
how many households we're talking about, how many companies are involved.
Oh, well, that's one other thing I did want to mention. So over the years, did I say this earlier? The department has recommended and the PUC has approved that, say in Burlington, which is a very competitive, you can have Burlington Telecom, you can have Comcast. We've basically relieved, or the PUC has relieved of most of their service quality obligations because, if they provide bad service, there's lots of other people to go to. Where we're talking about now are not so much the competitive areas. And I think when this current build out is finished, that Consolidated's doing, I think Hunter told me recently, he thinks there are going to be about 3,000 customers who are copper customers with no other options. And those customers are who certainly for the last 8 years, we've kind of been obsessed with. I know there are transition troubles from different technologies, and the older I get, our child gave us 2 things for Christmas that I can't make operate. One's a bird feeder, and so no, but you have to do the technology. I've reached the age where what now?
Well, obviously,
It takes
remote
pictures of the
control.
birds and tells you what kind of birds, and all this. So I know it, but once it gets set up, I think it's a great product that we have. But
The bird feeder?
well, the bird feeder actually
okay,
is
sorry,
okay.
trying to-
Yeah, it is.
I
And
wasn't sure if we'd switch topics.
but
Yeah.
the thing is, I think the service, and the one thing I will say about the battery backup, and I know that I think the FCC obligation has lapsed on that. I'm not sure that it's these companies' fault that the technology that they are being asked to provide is powered by the electric company. And as you may know, we're having huge proceedings now with resiliency due to the increased storms. And so there's a piece of the, whose responsibility is it that there's no backup? Is it the power company, or is it because it was the old technology of the copper? The old telephone companies, there would be a central office that served a certain area. Every central office had a big room. There was nothing but a bunch of batteries. And when the power went out, they produced enough power to get the signal over the copper. And that's why people's phone service stayed. And so when it was replaced with the fiber, it's just not possible anymore.
Rip Southworth?
So I don't know if you're the right person to answer this either of you, but I'm gonna ask. Since the carrier is going to a different voice service on their own accord, when it comes to underground services to houses, what responsibility do they have to run that new line to that house? Or do they have any responsibility to run that line to that house underground?
So that's a really interesting question because Green Mountain Power is doing a bunch of resilience work now, and they're burying underground, a lot of their lines underground. And we get calls from the communications companies who are being asked to do their facilities in the same conduit. I don't think there's a regulatory obligation so much as whatever their arrangements are with the companies that own the poles, formally
I think Representative Sarper is talking about drops to the house.
Yes.
Oh, I'm sorry.
Sorry, I didn't
I'm
make that
sorry.
clear.
I'm sorry. And what was your question about drops to that?
So because the company is changing their service, it requires a new line. Whose responsibility is it to pay that transition with putting new line into the house? Is it the companies? Do they have any onus or responsibility to do that?
There are tariff rates for the copper lines that come in. That's a good question. I live in Montpelier, and I swapped from Comcast to Consolidated, and Consolidated buried my fiber to my house at their expense.
Buried your
We have buried at our address, and so they agreed.
At no charge to you.
No charge to me.
So is there a way to find out if they have that same obligation during this process?
Just. It's a certain number of feet, and I'm not sure what it is, but
Like with cable, yeah, I think it's.
the federal rules do talk to that, but I do not know the answer off the top.
Yeah.
I would need to check that.
Yeah, and let us know. That would be great. Thank you.
I think earlier testimony we heard said, did they say 400 feet that the provider was obligated to run? And then beyond that, it was the customer's obligation. Maybe it was
I was thinking 200. Anyway,
split the difference. Call it the ratio.
Okay. So I'm thinking of 3 parallel tracks. Before we let you gentlemen go. So I am thinking about the FCC filing and the fact that we've got a lot of questions and concerns, and the fact that the department is considering, or sounds like will be asking, PUC to open an investigation into that. And I'm also hearing that the attorneys believe that you will be wading into the area of concern if there's any kind of conflict between what we believe the state has the power to do and enforce and regulate, and how the FCC decision plays out.
Well, it's also.
I know that's
to the
very high level.
commissioners. Yeah, I mean, I
And
would
the
go back to the
commissioners.
commissioners would make that determination.
Okay, so broadly though, what I'm trying to say is that the FCC filing, how the state of Vermont responds to that, that is an issue for this committee and for the legislature to stay informed about, provide oversight over, make sure we understand what's happening, because it informs our work. And it's really important. Unless I missed something. I also see the question of the MOU that's proceeding on its own parallel track and may be relevant to our bill when it gets over to the Senate or something, but we're not going to wait for it. And then I'm also seeing a draft that we painstakingly went through and should be ready for final language. And I want to make sure I'm not missing anything, which is that, is there anything important, relevant, or timely that you feel should be added to this bill, which we're voting on next week, that is relevant to the consolidated FCC filing? And I'm hearing no. Or is there?
Here's the only thing I would say about that. I defer to Maria 110% as to preemption issues. The battery backup, I think, as I mentioned, I'm a little concerned about it, but maybe not in.
She wants you to finish before I ask my question.
Oh, I've forgotten what the finish was going to be. I'm sorry.
Welcome to her world.
Welcome to my world. Yeah. Okay, so did you
Yes,
have a question?
I did. My
Okay.
question was, we are not requiring battery backup. Do you see an obligation here for that? So simply asking them to report on it? I'm making that distinction and saying to you, like,
So I'm going to answer it this way, and then I'm going to throw it to Mr. Burke. When I became telecom director at the department, the guy who was the head of the legal division, like I am now, he came to my office and he goes, I don't like telecom. I don't understand it. The lawyers don't. We're not helping you. So I went to the commissioner and I said, I'm going to have to hire my own very smart attorney. This is who I found, who is very smart and a good telecom attorney until he left to go to the PUC. So I'm going to ask him if he can answer this question.
It's specifically about preemption related issues.
so our bill,
Yeah.
I believe that Mr. Porter was raising a concern about our bill about the battery backup section. I was responding and saying, but Mr. Porter, we are not requiring them to do it. We're requiring them to report on it. And I'm very interested if the concern about it in our bill changes, given that we're not requiring, we're just requiring reporting to give department data for their consideration and monitoring of vulnerability.
I think unfortunately for Mr. Porter, the only response I could give to that on behalf of the commission is I've not heard from the commissioners any concerns
Okay.
about that particular provision.
And I've deferred to Maria.
Okay. So, just to complete my triple flip and stick the landing, we would love to be, remain posted on what's happening with the FCC filing. We'll be very interested to see the MOU whenever it's available to see, if the Senate might consider it relevant. And Maria, do you have what you need to deliver?
Draft to you?
Yep, a new draft. Did we answer all the questions? We had 2 TBDs we needed to return to.
Right.
The TBD was at the bottom of page 3, current telephone service. Is there any reason to change that language based on what you heard?
Sorry. Still no. Everybody rise.
No, you can just say, you can still say legacy voice service, because it is legacy voice service right now. Right.
What is better? There are many smart attorneys, many smart telecom attorneys in this room. You're being legendary, I would say. So we.
Wear that burden. No, well,
May I just ask, what if we just struck the word current and it said how it affects your telephone service?
yeah, I think so. I think we come up with something generic. It doesn't. Yeah,
So strike current.
yeah,
Okay, great.
yeah.
And at the bottom, another TBD. Midway down page 5, line 13, transition or discontinuance of service. What do you recommend there?
Oh. Well, you could do both. I would do both because as applicable, right? I think it's gonna be discontinuance, but maybe in some areas it's not. It's gonna be a transition. So maybe do both.
Rep. Southwood?
I'm not gonna speak over our attorney.
Oh, no, please.
I'm just using the words that she wrote, and it's discontinuance legacy voice. So I don't know if discontinuance or, I defer to you.
Well, so that
Absolutely.
was part of the question, because when we first started this, it was transition. It's just the network changing, right? But now, and maybe I got the answer today. Maybe it seems like all of the petitions are about discontinuance. Maybe not. That's why I wasn't certain if they, in different areas, they're
I'm not
just,
stuck on either way, and I
Okay.
prefer to you guys.
okay,
Oh, that's good.
Yep.
okay.
Covered it.
Rep. Sibilia?
Madam Chair, when you are done with this, I just have one more question for the department.
Let's let them go. Unless
Well, I
you
have
guys
one
want to
question for
stay
that.
here, our riveting.
When you're done with this, I want to ask them one more question.
Okay,
Are you ready?
no. So, but what I said was, why don't you ask their question? Because then if they want to go, they can go.
Yes, okay. So, in addition, we have received, and Rep. Paris Duncan just left, complaints from electric utilities also about this provider, and this major transition that's going on. Pole attachments, which we've managed not to, dive into here, and hopefully that will continue this year. But that seems to be a pretty big issue that is happening with the utilities and the poles, and what's left and who's going to be responsible, what bills are being paid or unpaid. And, we've heard from, we'll post this, but I don't know, I shouldn't say we'll post this. I will send it to the chair for her and send it to you. But we've heard complaints from, munis that there are issues here with they're lashing to the copper, and then so there are problems there with poles and attachments and the utilities, particularly some ones. Thanks, Madam Chair.
As you know, pole attachments are one thing we can deal with. Yeah, clearly. So yeah, we should send them our way.
Mhm. Okay.
So when Green Mountain Power buries their conductors, do they provide a conduit for the communications in that same pass through with their deal? Or are the communication companies left on the poles that Green Mountain Power is abandoning their conductors from?
The companies I've talked to, and I think the last one was Comcast, and I think there's an expense. I think they're moving their facilities. I can't remember if they have to be in different.
I can tell you, yes.
Yes.
Right, and I think that's part of the
The
complaint
National
is the
Electric Safety
expense.
Code does not permit a communication
That's right.
conductor to be in the same conduit
That's right.
as an energized electrical.
And I think that's been the issue I've heard.
But
I will say we asked a GMP witness about that in a recent proceeding, and we were told is they have a trenching tractor that they're using. And what we were told by the GMP witness was that they are trying to do outreach to the telecom companies before they move the lines underground. Whether or not that's leading to the telecom companies and the cable companies trenching with them, at the same time, I do not know.
it's putting a,
They did say they were doing outreach.
Thank you for your time. Really appreciate you being here. So committee, Maria will send basically a final draft and we'll post it, and we are gonna vote this bill on next week. I'm sorry, I can't find it on my notes right now, but just looking ahead, we'll have the agenda posted soon, I think. And next week we have a budget hearing with Adam Gresham and with JFO to talk about the ADS budget. That's on Tuesday. We're going to take, I hope, enough testimony on net metering and disconnections and data centers. So those three bills, to see what our next steps might be. So data centers, disconnections, and net metering We're gonna try to have some really foundational testimony so we can make some decisions as a committee. We are voting out next week the consolidated bill, the cell bill, and single plant. And that's what's going on. So we'll be getting the agenda. I think Alex is working on the agenda from Florida right now. Okay,
Do you have a single plant bill number?
710.
So,
Yep,
and
and
this one that we're taking
This has a
testimony.
weird.
DR, it's still a draft.
It hasn't been introduced.
Yeah, DR 260726. So votes next week on DR 260726, and it's gonna look exactly like what we just talked about. We'll vote out the cell bill, which is 527, and we last talked about that earlier this week, and we'll get a draft to folks as soon as it's ready, which that should be very soon. And then 710 is the consensus language that we went over with Attorney Hoffman from the PUC the other day that Ellen just basically